Okay, so for today, we're going to have a discussion of Cybersecurity Act of 2012 for under IT era or living in the IT era. No? So, okay. So, as what I have mentioned earlier, no, this will focus on the RA number 1017, the Cybercrime Prevention Act in the Net Commandments. No, the legal framework of the Republic Act number 10175 or Cybercrime Prevention Act of 2012 is in line with the Cybercrime Prevention Act of the Budapest Convention, which took effect in the February 2014. So the Philippine Congress enacted the Cybercrime Prevention Act on 2012, which addresses entirely crimes committed against and through the computer system on September 12, 2012. And signed by the President Benigno Aquino III, it includes substantive penal, procedural, and international cooperation roles. No? So a mandatory bills on cybercrime investigations area are work in progress in the Philippines, no? Aiming to introduce new procedural powers, responsibilities, and extrajudicial provisions. And these mandatory bills aim to provide a structured approach for prosecutors and investigations on cybercrime investigation and further align national legislation with the Budapest Convention. So the Cybercrime Prevention Act of 2012 focuses on the preemption, prevention, and prosecution of cybercrimes such as offenses against the privacy, confidentiality, integrity, and availability of computer data and systems computer-related offenses and content-related offenses. So, its original goals was to penalize act in Republic Act 9775 like cyber, sex, and child pornography. And RA 1017 like identity theft, no, and unsolicited electronic communications. However, various groups opposed the provision to expand the scope of libel law to cover internet posts, which led the Supreme Court to issue a temporary restraining order and a status quo anti-order. So the Cybercrime Prevention Act of 2012 could sentence internet users to up to 12 years in prison for posting defamatory commentaries on social media, take note of that, such as Facebook, Twitter, Instagram, and the like. So though online libel was not part of the original bill proposed by the Department of Justice, the Senate passed an amendment to insert it and was primarily proposed by Senator Vicente Soto III. So in addition, this act provides that crimes defined and penalized by the revised penal code as amended and special laws. It committed by, through, and with the use of information and communication technology shall be covered by the relevant provision of revised penal code, provided that the penalty should be 1 degree higher than the penalty imposed in the revised penal code as amended and special law. So furthermore, this act provides that prosecution under the Cybercrime Prevention Act of 2012 shall be without prejudice to any liability for violation of any provision of the revised penal code as amended or special laws. I just want to share a video presentations now about the discussion of data privacy, no? The cybercrime, no? Cybercrime Prevention Act of 2012 actually, no?
Hello, sir.
Ayan, maganda na po.
Hello,
This
and
meeting is being
everyone,
recorded.
especially to our professor, Mr. Marmelo Abante. Our topic for today is talking about the Cybercrime Prevention Act of the Philippines. The discussion will include Introduction, Cybercrime Prevention Act of the Philippines, the fundamentals of the Act, the key provisions of the Cybercrime Prevention Act of 2012, advantages and disadvantages of the Cybercrime Prevention Act of 2012, summary, and references. Let us start. According to research, the Philippines will be among the top 20 countries with the highest and widest internet usage by 2022. With 76 million internet users who primarily use social media and log on for an average of 4 hours and 12 minutes per day. With the rise of Filipino internet users now and in the near future, there has also been an increase in cybercrimes. The top most complaints cybercrimes here in the Philippines are online scam, online libel, online threat, identity theft, and photo voyeurism. Hence, the Philippines lawmaker passed Cybercrime Prevention Act of 2012 last September 12 of 2012, and it is officially known as Republic Act number 10175. The act aims to deal with legal concerns related to internet use and online interactions in the Philippines. There are three main categories of cybercrime offenses are penalized in Section 4 of RA 10175. Offenses against the availability, confidentiality, and integrity of computer data is part of Section 4 of RA 101. Under this is illegal access, access to a computer or any application without permission. Second is illegal interception. Any non-public communication of computer data to, from, or within a computer system that is collected through technical means without authorization, including electromagnetic emissions from a computer system containing such computer data. Third is a data interference. Computer data, electronic documents, or electronic data messages that have been improperly modified, lost, deleted, or otherwise harmed. This provision may also apply to the person's allowed activity if the person's conduct went beyond the mutually agreed upon limits and resulted in the damages set forth in this provision. Fourth is system interference. Unauthorized entry into a computer system or computer network is defined as the introduction or transmission of viruses as well as the input, transmission, destruction, degradation, alteration, or suppression of electronic data messages or computer data or programs. Fifth is the misuse of devices. Use, creation, production, sales, procurement, importation, distribution, or other provisions of tools, software, or other items made or modified for committing any of the offenses specified in Republic Act 10175 without authorization. Use of a password, access code, or other pieces of information that grants access to all or a portion of a computer system without authorization with the intent to use it to commit any of the offenses listed in Republic Act 10175. Lastly, the number six is cyber squatting. Dishonestly registering an internet domain name with the intent of making money, misleading people, tarnishing reputations, or discouraging others from doing the same. This includes trademarks that were already registered at the time of registration, names of people other than the registrant, and trademarks purchased with intellectual property interests in them. Those who obtain well-known businesses and individuals' domain names and use them to harm their reputation may be held liable under this clause. Remember that trademark infringement and free speech issues are usually dealt with separately. A party's right to free speech can be exercised without necessarily infringing on the names of brands or individuals. The second offense under Republic Act number 10175 is computer-related offenses. Under this is computer-related forgery. Unauthorized input, alteration, or deletion of computer data that results in inauthentic data with the intent that it can be considered or acted on for legal purposes as if it were authentic, regardless of whether the data is directly readable and intelligible, or the act of knowingly use computer data that is the product of computer related forgery as defined here to perpetuate. Second is computer related fraud, unauthorized access to, alteration of, or deletion of computer data or programs, or interference with the operation of a computer system with a purpose to cause damage. And lastly is the computer related identity theft, unauthorized acquisition, use, abuse, transfer, possession, change, or deletion of an individual's identifying information, whether natural or legal. And the third one under Section 4 of the RA 10175 is content related offenses. It includes cybersex for favor or consideration, willful engagement, maintenance, control, or operation, directly or indirectly, of any lascivious presentation of sexual organs or sexual activity via a computer system. Another is child pornography. Unlawful or banned activities conducted through a computer system are defined and punished by Republic Act number 9775 or the Anti-Child Pornography Act of 2009. This also includes libel, acts of libel that are illegal or forbidden under Article 355 of the Revised Penal Code as amended and are committed using a computer system or any other similar means that may be created in the future. Penal Code revision according to Article 355, libel is defined as defamation of character by writings or other means. Libel committed by writing, printing, lithography, engraving, radio phonograph, painting, theatrical exhibition, cinematographic exhibition, or any other similar means is punishable by prison correctional for the minimum and medium periods, or a fine ranging from 200 to 600,000 pesos or both, in addition to any civil action that the offended party may bring. Last one is unsolicited communications or spam, refers to emails or mobile messages that advertise products and services to a large group of recipients without their prior request or consent. Section 5 of RA 10175 lists other offenses like aiding or abetting in the commission of cybercrime. Anyone who knowingly assists or abets the conduct of any of offenses listed in this act will be held accountable. We also have attempt in the commission of cybercrime. Any person who willfully attempts to commit any of the offenses enumerated in this act shall be held liable. This is solely for handling violations and imposing appropriate penalties. According to Section 10, two government agencies are assigned: the National Bureau of Investigation and the Philippine National Police. We also have advantages and disadvantages of the Cybercrime Prevention Act of 2012. Let's talk about the advantages. Child pornography, cybersex, and cyberbullying are now crimes for which punishment is available. This act safeguards the rights of children. Second is this act defends all types of companies that use the internet as a distribution channel. Third, the definition of cybersquatting as an offense in this act's provisions has discouraged people from engaging in the practice. And lastly, laws that makes online identity theft illegal. The individual's privacy is safeguarded by this clause. On the other hand, the disadvantage is the ambiguity in the terms given in the Act, such as the term online libel is not defined anywhere, which can lead to different interpretations. Ambiguity can be seen in the provision of real-time data collection. Second, the ambiguity in the act may lead to the freedom of speech. The ambiguities, like the absence of a proper definition of online libel, may lead to confusion. Sometimes, the expression of some truth may be misinterpreted as libel. People may be restrained from expressing themselves. Lastly, the implementation and execution of this act yearly cause a huge cost to the government. Nevertheless, let us remember that there's a law that punishes unlawful acts online. Be an exemplary and responsible digital citizen that respects, protects, and recognizes the privacy of others online or offline. We have come a long way since the Cybercrime Prevention Act was passed and briefly suspended. Today's technological developments make everything immaterial easily accessible at our fingertips. Because of how pervasive they are, spam links may be disseminated to contacts on all social media platforms with only one click. We all require the highest levels of protection that can be provided to us, especially during this pandemic. The Cybercrime Prevention Act of 2012 is inclusive, thorough, and gives the complaint access alternatives. It is an act that constantly attempts to strengthen the protection of every Filipino internet user's rights. The fact that the actions and responses of designated authorities to cybercrime are still far from flawless.